Hi, my name is Dexter. I will be discussing the ancient legal maxim, which is defined as he who owns the land owns everything up to the heavens and down to the depths. Historically, English land law viewed land as three-dimensional, and this maxim suggested that the landowner enjoyed unlimited rights both in the airspace above and the subsoil beneath the surface. However, modern law has changed significantly due to developments in aviation, underground infrastructure, oil and gas extraction, and new technology. Today, the maxim operates only as a starting presumption, with courts limiting land ownership to what is reasonably necessary for ordinary use and enjoyment. Under this presumption, a landowner owns the surface, the airspace immediately above, and the underground beneath their land. Yet, modern requirements such as planes, drones, tunnels, pipelines, fiber optic cables, and oil wells demand flexibility, meaning that the maxim is not applied literally. Although a landowner still owns some space above and below their land, this is what this is limited to what they can reasonably use or control. In a modern context, this shift is essential because strict application of the maxim would prevent the functioning of everyday activities that society now depends on. For example, commercial aircraft routinely fly at high altitudes far beyond any realistic control of a landowner, while underground metro systems and utility networks run beneath countless private properties. If absolute rights to the heavens and depths still existed, these activities would constantly risk trespass claims. Regarding airspace rights, the key principle is that a landowner only owns the airspace necessary for ordinary use and enjoyment. This modern rule was established in the case of Bernstein of Light against Skyviews, 1978, where a plane flew over the claimant's house and took aerial photographs. The court held that a landowner has no rights to control all the space up to the heavens. They only control the lower airspace they actually need, while higher airspace remains part of the public freedom of flight. Trespass in lower airspace is still actionable. For example, in the case of Kelson against Imperial Tobacco 1957, a signboard projecting a few inches into a claimant's airspace was held to be trespass. Modern challenges such as low-flying drones, construction cranes, and delivery drones passing close to houses continue to test these boundaries, with courts applying the ordinary use and enjoyment test to determine actionable intrusion. Statutory provisions such as the Civil Aviation Act confirm that innocent overflights at reasonable height are not actionable, further limiting the old maxim. In conclusion, the maxim is only partly accurate today. Landowners have strong rights in low airspace but almost none in high airspace. As for subterranean rights, they are more complex. Historically, landowners own deep into the earth, including minerals, unless the crown had reserved them. Today, these rights exist but are heavily regulated by statutes and modern infrastructure needs. In the case of Grigsby against Melville 1974, illustrates this principle. Grigsby purchased a house that had access to a cellar located entirely beneath the neighboring land, Melville's property. Grigsby claimed ownership of the cellar due to access from his house, but the court held that the cellar belonged to Melville, confirming that ownership of land includes the subsoil beneath it. While these rights remain, they are restricted by statutes such as the Petroleum Act 1998 and the Infrastructure Act 2015, which regulate deep drilling and mineral extraction. In addition of these statutory limitations, modern development projects often require compulsory acquisition or statutory rights of access, further reducing the landowner's practical control over what lies beneath their property. Deep level activities such as geothermal energy projects, underground railway systems, sewerage networks, and large scale fiber optic installations operate at depths far beyond what traditional land law ever contemplated. This means that although the principle of subsoil ownership still exists in the theory, in practice, the landowner's control is confined to areas closely connected to the ordinary enjoyment and use of his land. Anything beyond this tends to fall within public interest regulation or state authority. As a result, subterranean rights today represent a balance between respecting private ownership and enabling essential national infrastructure, energy security, and technological advancement. In the case of Ocado SA against Star Energy UK onshore 2010, further demonstrates the modern application of subterranean rights. Star Energy drilled for oil at depths of 800 to 2,900 feet below Ocado's land without entering the surface. Although they held a statutory petroleum license, they had no permission from Brocado. The Supreme Court decided two things: whether the drilling at great depth amount to trespass, and if yes, what compensation should the landowner receive. As a final decision, it was held that this drilling constituted trespass, confirming that landowners retain broad, sub, broad subterranean ownership. However, the compensation awarded was minimal because the drilling did not interfere with Ocado's actual use of the land and was authorized under statute. In conclusion, the ancient maxim remains symbolically important, but no longer reflects the full reality of land ownership in England. Courts now limit airspace rights to what is necessary for ordinary enjoyment, while statutory rules restrict subterranean rights in the interest of public resources and modern infrastructure. The case of Boccardo against Star Energy exemplifies this balance. Although the landowner technically owned depth underground space, statutory regulation and compensation rules prevented any substantial financial gain. Overall, the maxim survives as a starting point rather than a complete rule. Thank you. OK，10分钟了。 刚刚好。